First, I'm going to introduce Preslava Todorova, who is from the ERCS, the Environmental Rights Centre Scotland. She has got really broad experience in legal research and analysis, as well as project management. And prior to joining ERCS, she worked on research in the field of renewable energy and greenwashing. Her past work with a Glasgow-based environmental startup included policy research for saline water farms in the west of Scotland, and alongside working for ERCS, she volunteers for a rewilding charity, and she is leading their work on freedom of information. And some of you may well have experience in doing FOIs before, and as I have, but I have never had a proper education in how to do it. So I think this is going to make my campaigning far more effective. So over to you, Preslava, and thank you for joining us.
Thank you, Kat. Good evening, everyone. I'm just going to share my presentation now. Okay. Hopefully that works, and you can see my presentation. Okay. Good evening, everyone. My name is Preslava Todorova. I'm the Assistant Legal Officer at the Environmental Rights Centre for Scotland. The Environmental Rights Centre for Scotland is an environmental law charity. We carry out advocacy and policy and law reform in order to improve environmental rights and full compliance with the ERCS Convention on access to information, public participation, decision-making, and access to justice on environmental matters. So today I will talk about making information requests under the Freedom of Information Scotland Act and the Environmental Information Regulation Scotland. I will explain how to draft an effective request and what to do if your information request is either refused or is not fulfilled properly. I will also briefly touch upon the role of the Scottish Information Commissioner in the process. So to start off, anyone can request a recorded information from a Scottish public authority. What we mean by recorded information, this includes emails, reports, planning minutes, photos, videos, any information that a public authority holds is information that you can request. And subject to certain exemptions, public authorities have a legal duty to disclose this information. The information you request can relate to any functions of the public authority, any of its work, and decisions that it has made in the past. First of all, it's important to draw a distinction between the Freedom of Information Scotland Act and the Environmental Information Regulation Scotland. The Freedom of Information Scotland Act provides a general right of access to recorded information, whereas the Environmental Information Regulations apply to specifically to environmental information. And this can be information ranging from air quality reports, water quality reports, biodiversity, monitoring data and impact assessments, emissions, and environmental policies and plans. The key differences between the two regimes outside of the information which they cover relate to, first of all, the manner in which an information request can be made. So this can be done verbally when it comes to environmental information, whereas information requests under FOISA need to be in writing. Also, there is a difference in the time period which a public authority can take to respond to your information request. Under the Freedom of Information Scotland Act, this is 20 working days, but under the Environmental Information Scotland regulations, this can be up to 40 days. Although this is an extension which applies only in cases where the information is very complex and the public authority needs more time to fulfill it. So this is not the usual time frame. There are also different charging rules. So under the Freedom of Information Scotland Act, if a request for information is likely to cost the public authority more than £600, they may refuse to respond. Under the Environmental Information Regulations, there is no upper cap, but they could ask you to pay for the amount of time that they have spent on a specific information request. Lastly, there's also a very, very key difference, which is the broader definition of Scottish public authority under the Environmental Information Regulations. So under that regulation, the definition extends to legal persons who are not necessarily a public body, nor do they hold any public office, but they do have responsibilities which relate to the environment, and they exercise functions of a public nature. So in more plain terms, this can be any company which is publicly owned, or it can be an entity which is generally under the control of a public authority. For example, Scottish Water is a publicly owned company, and Scottish Rail Holdings also falls within this category. Before you make a Freedom of Information request, it's important that you do some research and try to identify if the information is located on the public authority's website. It's good practice to check, and also it's good practice to check if the public authority keeps a register of Freedom of Information requests and responses. Some public authorities do this, others do not. The Scottish Government, for example, posts all of the Freedom of Information requests and responses on the What Do They Know platform. And similar platforms can also be useful to identify whether someone has asked for what you need already. But if the information cannot be located, then we move on to the drafting of the Freedom of Information request. Also, I would like to make clear I'm using Freedom of Information request interchangeably for both information requests under the Freedom of Information Act and under the Environmental Information Regulations. I just want to clarify that it is not your responsibility to define whether your information request is going to fall under one or the other regime. This is for the public authority to determine, and they will determine this in their response to your Freedom of Information request. So before you start drafting your Freedom of Information request, I would like to mention that this doesn't need to be a request which is formalized as such at the outset. For example, you may already be in correspondence with the relevant public authority, and you may have already asked some questions or asked for specific documents. In this instance, if you haven't received a response, or if you have received an unsatisfactory response, you can send an additional letter or email in which you clarify that you would like your specific email to be treated as a Freedom of Information request. This can be helpful if you know that you have already asked for the information, you have not received a response, and this way you can formalize it as a Freedom of Information request. And from that moment onwards, the public authority will have 20 working days to respond to you. However, if you are drafting a Freedom of Information request anew, the key principles in drafting this are to be clear and concise and ask for the information that you specifically need. Overly broad requests may take longer to process, and they may be refused on cost grounds. They may also be refused on grounds of requesting very broad general information, or they may result in an overwhelming amount of documents being sent to you. So structuring your request clearly and defining any timeframes where timeframes are necessary is crucial. And if you know what piece of legislation your request relates to, if it relates to any piece of legislation or any piece of policy, then I highly encourage you to include this at the outset of your request. This way, you would be making it very clear to the public authority what the information is. And you can follow this up by requesting specific documents. And I normally do this in a numbered way or in a bullet pointed way, keeping sentences short and paragraphs short and to the point. Depending on how you send your request, you should include your email address, postal address, and of course your name. Under the different regimes, as I mentioned, there may be costs associated with the information request. It's also important to keep in mind that following drafting your request, you may end up receiving a large amount of documents. So it's important to keep in mind how much bandwidth you have and to what extent you can review very technical information if you are requesting this, or if you have suspicions that technical information may be included in the response. Sometimes it can take a very long time to go through very wordy documents and email chains which continuously refer to one email or another. So keep this in mind when you're asking for information. And again, if you can apply certain limitations, such as dates, any other type of framing, it's advisable that you do. Public authorities must normally respond to your request for information within 20 days. As mentioned, this may be extended to 40 days in exceptional circumstances for requests under the Environmental Information Regulations. The Scottish Information Commissioner has a very helpful response calculator on their website. And what this response calculator helps to do is determine the exact date, which is the deadline for receiving a response to your request. The response may result in full disclosure, partial disclosure, a refusal, or a statement that the information is not held. And carefully reviewing what you have received and assessing whether it genuinely answers your question is the first step to reviewing the Freedom of Information response. Now, in terms of responses which are not received within the 20-day statutory timeframe, this amounts to a failure to respond on the part of the public authority. Once you've received and evaluated your response, it may become clear to you, it will become clear to you how to proceed forward. You may have received a response which is incomplete. So an example of an incomplete response may be you have asked for the correspondence between the public authority and a third party. You may have requested this correspondence to range from 2022 until 2023. Upon reviewing the information, you've identified that certain emails which are referred to or which are logically expected to be there are not present. So this is an example of incomplete response. Another example can be if you receive information from a public authority which includes a document which has been redacted in a manner which doesn't correspond with usual redactions. Usual redactions would normally redact personal information such as names, emails, telephone numbers, and information which can be assumed to be confidential. However, you may encounter redactions which you do not understand the placement of. So this would also lead to an incomplete response on the part of the public authority. If the response you've received states that the public authority doesn't have the relevant information, this can also be information on its own, especially if you're aware that the relevant public authority should hold specific information. For example, if you know that a public authority must have written policies and procedures in respect of some of their functions, if they respond to you that they do not hold these, this can be helpful in you understanding that the public authority is possibly non-compliant with its legal obligations. And this can be very helpful for campaigns. So if you're unhappy with the response you've received, you have the right to request that the public authority review the response. You must do so within 40 working days of receiving the response or within 40 working days of the deadline of the no response being issued. Your review request has to be in writing, and it must explain clearly why the response was inadequate in your opinion. After this, the public authority has 20 working days to reply to you. That is what we call a review response. When you draft your request for review, you basically can base this on the response you have received, and you can follow the response for ease. First of all, if you have not received a response at all, I would follow up by reiterating my asks from the original Freedom of Information request I sent. I would refer to any reference numbers I may have received from an acknowledgement email from the public authority, an acknowledgement letter. And I would also finalize the review request by stating that if I don't receive a response within 20 working days, I will refer this to the Scottish Information Commissioner. So that is if you have not received a response. If you receive a response which is limited and only responds to your query partially, you can again reiterate your asks, the ones which have not been covered. Apologies. But I would expand on these. I would explain why I believe the public authority has failed to properly respond to my request. And I would also provide any additional information I think would be fitting. For example, with the example of a missing email from an email chain, I would refer to those documents and I would explain the mistake that may have occurred or the fact that I'm noticing that something is missing. The most challenging aspect of responding to a review request comes when you have received a response which is not disclosing information because the public authority is relying on certain exemptions. There are exemptions which apply to both the Freedom of Information Scotland Act information requests and to requests under the Environmental Information Scotland regulations. There are some differences between the exemptions as well, but I'm not going to go into too much detail about these. I would just like to note that for the requests made under the Environmental Information Regulations, the public body can refuse your request if an exemption under the relevant legislation applies, and where the public interest in making the information available to you is outweighed by the public interest in maintaining this exemption or withholding the information. What this means is that public bodies under the EIR are obliged to interpret an exemption in a restrictive way and to always hold a presumption in favor of disclosing the information to you. Requests made under the Freedom of Information Scotland Act are different in the sense that the public interest test applies only to some of the exemptions, not to all of them. So some of them are absolute. So if the relevant public body has relied on a specific exemption and is refusing to provide you with the information, you can still challenge this. Simply because the public body relies on the exemption, it doesn't mean that the exemption is applicable to the information in question, nor does it mean that the public interest will be served best if the information is withheld. So in circumstances like these, it's always good to read the text of the exemption and relate this to the information which you are actually seeking, because you know best what you actually need from this public authority, and find out if the exemption even applies. It's surprising how many instances there are of public authorities applying exemptions to information which doesn't really fall within that exemption. So you have the right to challenge this. And when writing your review request, I would suggest to clearly outline your arguments, refer to each one of the reasons behind the public authority's refusal to disclose or exemptions which they have relied on, and number each one and use the same numbers in your review request as well to respond to them directly. You can start off by stating the reasons why you believe the response is insufficient. And if you have more than enough reason, I would also number the paragraphs to make it easier if in the future you need to refer to specific arguments. Explain your points plainly and succinctly. Again, short sentences and short paragraphs, in my opinion, work best to very clearly convey the information. This can also include, for example, making it clear that you've identified that there is correspondence missing, and referring to specific pages of the PDFs that they have sent of email chains, or that a public body has failed to send certain documents, you can refer directly to the documents that they have sent you, directly refer to your Freedom of Information request and explain what's missing. There's some more common grounds of refusing information than others. For example, the public body might say that the information is not held. It can also rely on the costs argument that that completing the information request will cost more than £600. They may also state that there's commercial confidentiality associated with the information you're looking for. In this case, you can certainly challenge this, and you can explain why you believe that commercial confidentiality may not be prejudiced. Documents might be part of an ongoing investigation, or they may be information which is part of legal advice which the public authority may have received from their solicitors. So that would fall under the legal professional privilege exemption. Important to note that under the environmental information regulations, information about emissions has special status, and there are some exemptions cannot be relied on when it comes to information for emissions. In terms of how to analyze the review response, Suzanne Cross is going to speak in more detail to this. I'll just wrap up by briefly explaining the how to submit an appeal to the Scottish Information Commissioner. If you're not happy with the response you received to your review request, you can appeal to the Scottish Information Commissioner. If you do, it would be very helpful if you have kept records of your email correspondence with the public authority in question. Usually it's required to provide specific timelines and specific dates about this, and also to provide actual copies of the email correspondence as well. So keeping records and keeping everything very neat is very useful when it comes to this stage. Keep in mind that the Commissioner issues a final decision. However, this may take some time. There are no time frames for the decision to be finalized. So it could be several months before you receive this. However, you will receive a reference number once you've submitted your appeal, and you can ask for updates with the reference number. Final remarks from me. I just wanted to emphasize that throughout the entire process of Freedom of Information requests, it's important to keep a clear focus on what is the essence of the information that you're looking for. And this is throughout the drafting of both requests and the appeal to the SIC. Freedom of information is a powerful tool for accountability, and with carefully prepared information requests and precise drafting, you can gain valuable insights into how decisions are made and into whether public authorities are complying with their legal obligation. Lastly, the Environmental Rights Centre for Scotland advises on matters related to access to information. So if you have any questions, please contact us on our Get Advice page. I will also paste the link into the chat. Thank you.
Thank you very much, Preslava. So we've had a few sort of really simple questions that I'll put to you now, but the more complicated ones we'll leave until the end. There's just a few that perhaps would be useful just to answer now. So I had one from Alex asking if there's a standard form, and I'll ask that at the same time as one from Nikki asking, is the process the same for the UK-wide bodies? For example, Health and Safety Executive or NESO, which is the Energy System Operator.
Thanks, Kat. Yes, so in terms of the first question, I believe there is some standard forms available on the Scottish Information Commissioner's website. I can have a look, and I can paste these in the chat. And in terms of the second question, if the process is similar to Freedom of Information requests in the UK as a whole, I believe so. I believe it is similar.
Great. And there's a question from HP asking, when is it appropriate to refuse to supply info as it's deemed commercially sensitive. So they're asking, I think they're asking, who decides what's commercially sensitive and what isn't?
Well, this is one of the exemptions which can be challenged because what is deemed commercially sensitive at the end it would be if the process reaches the Scottish Information Commissioner, it would be the Scottish Information Commissioner's decision that deems what is actually commercially sensitive and what isn't in that instance. The way that one can challenge this is based on the information that you have asked from a public authority. If they have used this exemption to refuse to give you this information, you can explain why you believe that the commercial interests of the third party will not be harmed by receiving this type of information.
Thank you. There's one from Jill Sword that came in advance by email, which is how can we ensure that the information is full and complete? And I suppose it's difficult to know if there is an email missing or whatever, if it's not very obvious from the chain. But have you got any experience sort of to share from your own kind of FOIs you've done where you can kind of spot if something isn't quite full and complete?
Yes, sometimes it's very obvious. Sometimes a public authority may just not respond to, let's say, point one of the FOI request, but respond to the other three. But in terms of wider, more encompassing responses, it is difficult. It can be difficult, and the way to ensure that there's no way to fully ensure that you're going to receive complete information. But that's what I wanted to emphasize earlier in my presentation, that if you delineate the information that you're trying to receive, if you put enough factors which need to be taken into account, such as specific dates, or you can even request the information between only the local authority and a specific operator, not everyone involved in the development. Try to make it as cohesive as possible. But the only one who can ensure that they sent you full information is the public authority.
Thank you. So I'm going to hand over now to Claire, who will introduce Suzanne. But there's a question I think that Suzanne will answer in the presentation she's going to give, which is one from Carol-Ann Taylor, which says, can you define when FOI should be used as opposed to just asking for the information? And I think probably it will become clear in what Suzanne says. So over to you, Claire.
Hello. Yes, thank you for that, Preslava. As always, Environmental Rights Centre Scotland presents its information very clearly and succinctly, and I do recommend this organisation if it's the first time anybody's heard of the Environmental Rights Centre Scotland. Go to their website. They're pretty fab. So I'm Claire, and I'm from Planning Democracy, and we work very closely with APRS. Kat did mention that we've done a manifesto, which we are going to talk about on the 10th of March, and I'll put a link to it in the chat, but I won't go into detail about that tonight. But that's the 10th of March webinar. We're going to be talking about that again with the Environmental Rights Centre Scotland. But now I'd like to introduce Suzanne Cross from Save Our Green Space, or SOGS, which is a campaign group that was formed in opposition to a 66-house development on the outskirts of Invergordon. And the site is the last remaining wild natural green space in town. And she'll outline the campaign that they have run and the reasons for it, I have no doubt, in her presentation. But I contacted her about 2 years ago, I think now, Suzanne, wasn't it, with some questions that we were doing to help us with some research, and we had specific questions about the development and wondering what the community were thinking about some rather unusual conditions that they put on it. And it soon became clear that Suzanne was a really skilled campaigner and activist, and we have worked quite closely together actually. And 2 years on, it's been a long battle, which Suzanne will go into, but the latest aspect has required a really brave decision to take a legal challenge in the Court of Session. And sadly, this was not successful. You heard about it last week, didn't you, Suzanne? The campaign are now considering appealing this decision, which they're not sure whether they're going to or not yet. But the guaranteed fact is that the campaign have already spent thousands of their own money on this legal challenge. But if it's going to be appealed, and it's quite an important appeal in terms of protecting ancient woodland in the future, so it's got some sort of important precedents. We think it's important for them to appeal. So I would recommend that people really consider donating to this cause. It's a really important one. So I'm just putting their Just Giving page up in the chat, and please give generously to this fantastic campaign. All right, now take it away, Suzanne. Thank you very much.
Oh, thank you, Claire. And yeah, just really great to be here. Planning Democracy, APRS and ECRS have all been really key to our campaign. So it's a nice opportunity to be able to give back and share our experience with FOIs. I'm just going to try and put my slides up. Is that, oh, 1 second. There we are. Perfect. Okay. So yes, I'm Suzanne. I'm from SOGS, not the sexiest of acronyms, but there we go. And yeah, so first of all, just to give you a bit of background to SOGS and our campaign, to try and provide a bit of context as to the freedom of information that we requested, and then how we used it within our campaign. So we were formed in late 2023, as Claire was saying, in opposition to a housing development that was planned for the outskirts of a town called Invergordon in the Scottish Highlands. So the town is officially classed as deprived and is just about to see huge industrial expansion. It was awarded just 2 or 3 years ago Green Freeport status. So that's going to significantly change the landscape of the town. Yet the site is the last remaining wild natural green space. It's really key to the community's well-being and its cultural heritage. It's a greenfield site, so it's never been built on before, and it's surrounded by ancient woodland, both of which National Planning Framework 4 is meant to protect. So this is when it starts to get a bit more technical. So the site had been allocated for development in the outgoing local development plan from 2015. So it had been designated for housing at that time in 2015. The incoming plan in 2024, so it's now the current plan, at that time it was incoming, had deallocated the site for development. So it was no longer considered appropriate to build on. And at the time that the planning decision was made, the new plan was meant to be the sitting view of the council at the time. The planning application was first heard and approved by the planning committee in April 2024. And at that time, that would have been the last committee meeting under the old plan before the new plan came into power. The planning application then went back to committee in March 2025 after intervention from our solicitor. So it was then heard under the new plan. It stated in the committee report that it no longer complied with NPF4 or the local development plan, but it still recommended approval, which was granted, and very likely influenced by the fact that it had already been granted under the old plan. So it was at this point that we filed for judicial review. And a couple of key points, I mean, there were so many things in this application that were concerning, but a couple of the big points. In terms of required biodiversity net gain, sadly, it's not law in Scotland, it is in England, but we have guidance around biodiversity net gain, and the Highland Council, their guidance states that developments are required to demonstrate a 10% biodiversity net gain. For our development, there was a 0.76%, and the habitat survey that fed into the biodiversity net gain was done out of season in the middle of winter. So this net gain was tiny, and the calculations were flawed when we looked into it a bit more closely. and also trees within the ancient woodland were to be cut down for the drainage route. So as Claire shared, the spoilers, we lost the judicial review. We just found out last week, and yes, we are exploring options for an appeal, and grateful to Claire for mentioning that. Even if worst case scenario we're not successful, we have no regrets in trying, and there's been a lot of positives that have come out of our campaign, and the freedom of information has undoubtedly played a really important part in that. And whilst it's difficult to acknowledge, we do wonder whether it might have played a bigger difference had we approached it different. Had we had this 2.5 years ago, it might have made a difference. But yes, it's good that you guys can learn from things that we maybe should have done differently or better. So just to go over the timeline, so Preslava's already covered this in terms of the different stages. But one of the things, we delayed in getting our FOI in. So we, the application was approved in April 24. We didn't put in our first FOI until November 24. And that was absolutely down to a lack of knowledge and not really understanding what to do and what information we could gain. So I think something really important is to be prompt. The local authority failed to respond within 20 working days. So that starts, the 20 working days starts the day after, the first working day after you've submitted the request. And you can then respond on day 21, the working day 21, if you haven't heard back or if the response isn't adequate. We did that. We put in a request for review. They failed to respond again. And then eventually we went to the Information Commissioner. And I highlight eventually because we also delayed with that. I was sending passive aggressive emails, I think 4 or 5 emails saying it would really help everybody involved and save time and energy if you can just get back to me on this and I won't have to go to the Information Commissioner. We shouldn't have done that. We should have just gone straight to the Commissioner and saved time. So a few tips: be prompt, keep a copy of everything. There was a form on the Highland Council website that we filled in that just had each of the sections, but for us, for their system, we got an email confirming that we'd submitted the FOI, but it didn't say what we'd asked for. So make sure you keep a copy of that. Make a note of all the submission dates, the review requests, schedule reminders in your calendar. That's an important one, just so you can be on it when you're getting to the next stage of the process. Share this information with others. We were a really small team and I kind of led on the FOIs, and we ended up submitting a few, and this then ended up becoming quite jumbled later on. So I think sharing the information with others and being really structured in the way that you approach things, but also the way that you record things. So it can be helpful to have a spreadsheet, particularly if you're doing more than one. So a spreadsheet with the FOI, the reference number, the date it was submitted, the date you expect to hear, the date the review was requested. That ended up being really helpful for us. So next bit was going on to the Information Commissioner. Again, I won't go into too much detail here. We used the form on their website to submit the request to them, and they list the required documentation, so evidence of when you'd submitted the request to the authority in the first place and when you'd submitted the review. I've had a wee tip here about being mindful whose name you put on the form. We used my name, and then I took a sabbatical last year and went away for 6 months. And it ended up being a bit of a faff because then I had to provide permission for the name to be changed. And so just make sure it's someone who's going to be around and is, kind of consistently available, even if you end up kind of responding on their behalf, but just so that they're about and, know what's happening. So we'd emailed the Commissioner. They started to look into it. In the meantime, the authority actually responded just before the Commissioner had... so the Commissioner confirmed that the authority had failed to respond within the allocated timescales. But in the meantime, the authority did respond with a 178-page document. We queried missing information and redactions directly with the authority, and they did respond with giving us more information, but we still didn't believe that that was everything. And at that point, we went back to the Scottish Information Commissioner. I'll come back to that just in a couple of slides. So this next slide is about reviewing the information, and I have someone sitting meditating calmly on a lake as an example of exactly how I didn't feel going through this information. And I think an important point is just to take a few deep breaths before you jump in, a bit of grounding, and yeah, just I think being aware that if you're anything like us, you're fighting for something that you feel really passionately about and you have a really strong sense of injustice, and there's a huge emotional investment. And when you start going through that material and seeing things that confirm concerns that you've had all along, and knowing that there's those discussions that have been had internally, can be really difficult to see in black and white. But also, I think it's difficult not to hope for that silver bullet, not to want that, scenes of Erin Brockovich going through your head, and the likelihood of finding that key document that's going to blast everything apart is slim. So I think it's just really managing your expectations around how you tackle the information and how you approach it. So as I say, our first FOI was 178 pages long. This may seem super daunting to begin with, but some of the information will be irrelevant. A lot of the information for us was duplicates of emails, so you could quickly skip through them. And you'll quickly identify the information that's really jumping out to you. Not all of the document will be searchable. Some will be screenshots of other documents, but some of the information will be searchable. So I would recommend searching for keywords and phrases, and that can help select specific information for you. Keep a note of page numbers, because it is an absolute pain when you see a specific piece of information that you think is really key, and then you go away again and you didn't take a note of where you'd found it. So that's an important one. I don't know if you're also familiar with the snip tool. There'll be an equivalent with Mac, but in a Windows, if you go to the Windows search bar and put in snip, there's a brilliant tool that you can use that literally you can take just a snippet of what you're looking at, the information you want to select, and then copy and paste that and put that in a separate document. That's what we did. So it meant that we could pull out themes and then have all of the information in separate documents. Again, keep a note of the page number of where you've taken that snippet from. That can also help with emails, because a lot of the emails won't be in chronological order. So in order to get like a proper trail of communication, it can help to snip and then put in a separate document, and then you can identify the communication trail. Also important to keep an eye on dates, and this is something that Preslava, you touched on it as well, is that there can be big gaps in email trails, and that's something that we went back to the Commissioner about, that the conversation had obviously moved on, but there was, so biodiversity, for example, was one of the FOIs that we put in for information referencing biodiversity, and there was gaps of 4 months between emails, but the conversation had obviously moved on in that time. So that to us provided evidence that we potentially hadn't been given all of the information we requested. Keep a note of redactions. As Preslava was saying, the authority is meant to explain any redactions, and if they're not explained or you're not satisfied with the explanation, that's also something that you can raise with the Commissioner. Pull out themes. So we were given information obviously on the things we requested, so that was specifically around biodiversity, bats and local development plans, but there were other things that came out of the information that we hadn't asked for, and that's ended up being really important for us. So just keeping an eye on whether there's any other things that are jumping out for you, and then put in more FOIs. That's what we did. We found some information and we thought this looks like an interesting route to go down, and then we put in another FOI. If you have enough capacity, have more than one person going through the documents. We ended up receiving a lot. And again, it was predominantly me going through them, and some of them, there's still things that I hadn't spotted when I went through them originally, and it can really help to have a second person to share that responsibility with, and to split that load. The other thing that I would recommend, there will be some documents that you can kind of confidently skim through. There's others, for example, contracts. We had the experience of this, that we didn't read them maybe as closely as we could have done. And I would recommend that if you do have the time to read carefully, because again, there might be some important pieces of information that can be relevant to your campaign. And take your time and go back to it. It can feel really overwhelming to begin with, but it will become increasingly familiar. And if you're able to approach it in a kind of somewhat systematic way, then it absolutely becomes more manageable. So I'm now going to share an example from our FOI. I'm going to read it because it's quite a lot of text, so bear with me. And again, I had to reorder all of these emails. This wasn't nice and neat in this order. So February 24, Ecology Officer within the Highland Council to the Principal Planner. I've had a look at the biodiversity net gain proposals, and these are very poor and not nearly enough for the site. Off-site measures or contributions are really a last resort measure and should not be viewed as an easy option to not provide mitigation, compensation and enhancement within the site. So 20th of March now. So bearing in mind this was four weeks before the committee meeting that approved the development. Principal Planner to Bracewell Stirling Architects. So that was the architects for the developer. I've discussed the ecology, and if the suds pond is a wet suds pond, this will be enough on site, with off site being secured via a planning condition if the Highland Council own the site. Bracewell Stirling Architects, the Principal Planner. With regard to securing off site biodiversity improvement, the Highland Council will not own the land. It will be the developers, or until such time as can be transferred to a community woodland group, and bearing in mind that the community were completely opposed to the development. Principal Planner to the Ecology Officer, and the bits in red are the bits that had been redacted and were unredacted when we'd asked further about that. So the saga continues. The Highland Council will not own the land, with exclamation marks after. Ecology Officer to Principal Planner, oh heck, I'll need to chat to you, redacted, about this. So it's a Highland Council development, but they won't own it. I'm getting confused. Are they still going for May committee? Principal Planner to Ecology Officer, they're wanting April committee, but I've not even started the report as there's so many things outstanding. It appears it will be a Highland Council development, but they will not own the land. I'll have to speak to the head of development to get clarification on this. More exclamation marks. Email from Principal Planner to Area Manager North Highland. I asked the Ecology Officer to make some suggestions on how they can improve the on-site biodiversity, but the off-site will still be an issue if the Highland Council don't own the land. So this was just a few weeks before the April committee. So the development was approved at that point by the planning committee. There was no mention of the 0.76 biodiversity net gain. They referenced that it was low. They didn't reference the specific percentage, and there was no off-site enhancements included. And then 2 months later, the Highland Council bought the site from the developers before the final decision had been noticed. But disappointingly, when it went back to the committee in March 25, they still hadn't included any further enhancements. So that was just an example of what we managed to pull from the freedom of information. And what it revealed was that in reality, there appeared that there was a lot of unresolved concerns. Ecology was not supportive at that time. There was pressure to make it to the April committee, which is what we had speculated about all along, and that they appeared to be workarounds, and these things never made it to public record. And it also provided evidence of process failure, and that there were major issues that were being discussed repeatedly in internal emails, but obviously not referenced in the committee report. And this all helped us to understand where we needed to be focusing our attention. So after the review of that 178-page document, and identifying that we believe there was still information missing, we then went to the Commissioner again in March last year. We received a response in December, but we also would have contributed to delays there because, again, they came back to us a couple of times and asked for additional information. And because I was the person who had that, there was delays because I was overseas, so it might not have taken quite that long. The Commissioner found that the authority should have handled the request under the Environmental Information Regulations, and the authority admitted that this had been overlooked. The Commissioner, with the Commissioner, it was a much bigger document. These were the kind of two main points for us, that the search terms used for email searches had been insufficient and too broad. So the authority was required to conduct further searches and respond by the 5th of February, which they did, with a further 600 pages. Although very kindly, it was split up into 4 150 pages, which made it a bit easier to manage. But again, sounds very daunting, wasn't actually too bad, because you have an idea of what you're looking at and the important bits that you're pulling out. So tying it all together, main tips: submit promptly, track everything, escalate quickly, share the workload, and stay systematic in your searching and your recording of what is there, but also what you think is not there. And actually, going back to a point that I should have referenced, when we first went to the Commissioner to say that we thought information was missing, at this point, the advice from the Commissioner is that we didn't have to be specific about what we thought was missing. We just had to say that we didn't believe that we'd been provided with all of the information held by the authority in respect of our requests, and to state that redactions were unexplained. Later, however, they did come back to us to ask what we thought was still missing. So, but that initial contact, we didn't. So, but maybe still keep a note of what you feel might be missing. So yes, so being systematic in your approach to it. And in terms of how we use the information, there was that confirmation of issues and confidence in what we were looking at, and really shifting the focus from we don't like this decision to this decision process may not have been robust, transparent, or policy compliant. It meant that our concerns were now evidence-based, not just kind of speculative, confirmed that key issues were known internally, but didn't and appeared not to be resolved. And obviously it's challenging because this is just a snapshot in time. You don't get the information that, you know, the ongoing evolution of those conversations, but at that snapshot in time, key issues were known and they had not been resolved. And we could then feed this back to our solicitor. It highlights other issues and other routes to go down. So in that example that I gave you about the Highland Council not owning the site, that we then put in another FOI about land ownership and the purchase of the site. And we'll see what happens with the appeal. And worst case scenario, if we don't win it, we have been able to use the information to ensure, or we will use the information to ensure that if the development does go ahead, that no corners are being cut when it comes to biodiversity in the woodland. And we will ensure that the authority are going to do what they say they were going to do. And the sharing of the information has also been really important from the point of view of generating local support. More recently, support from within the council. And also means something, it's something that we that's been very concrete to go to the press about, and we're really hoping to get some national press coverage soon. And I think lastly, there was a lot of reference to SOGs in the emails, in the internal emails in the council, which was interesting and gratifying. But I think there's something really powerful and really important about the authority knowing that we know that they've had concerns and that mistakes have been made, and we have evidence on this, and that we are watching, and we will continue to do so, and hopefully that will have an impact in what they do going forward. So yes, hopefully that's been helpful. And yes, I've included our email on our website in case anybody wants to find out any more about SOGs or wants any further information.
Thank you very much, Suzanne. That was fantastic. I wanted to go back to Claire briefly and just ask you if there's anything that you wanted to add in terms of what you thought FOI brought to Suzanne's case, from your experience of obviously seeing lots of planning cases.
No, I think really Suzanne captured it. The key point was that it does highlight what's going on, those internal conversations, and it gives you an insight into what's going on, because otherwise you just don't know where, you know, whether it's you're being a bit paranoid or whether it really is, you know, and a lot of them, particularly from the SOGS campaign, was really, I felt, enlightening about what kind of conversations were being had, and it just throws it takes a veil off the lack of transparency that you normally have. It helps with that transparency, I suppose. So I think that was the key thing, really. But yeah, no, Suzanne's really covered an awful lot around the thing. I'm not sure I could further add to these excellent presentations.
Yeah, absolutely. So I think that pulling the veil away is the thing, and seeing how people really feel underneath. But so I've got a few more questions. Some are a bit in depth. If anybody's got a question specifically for Suzanne, that would be really good as well. Please do let us know. I'm wondering, someone emailed one in, and I'm not sure if they're here, because it would be good if they might quickly go over it. It's Paul. I'm looking for the email. Hold on a minute.
Paul Davison. Yeah.
Yes. Are you there, Paul? I'm not sure. Okay, what I'm going to do is start reading into this. It's quite a specific question, and I think we might have to come back to Paul with some answers, but it's something that's obviously meant for Preslava. He's got a question. He says, a DESNES refusal to provide the greenhouse gas emission calculation and assumptions establishing compliance with the low carbon hydrogen standard. So this was because it was crucial for MPF4 policy 13 compliance and planning approval of a green hydrogen plant, because of EIR regulation 12.5e, confidentially or commercial information. And this is something we might have to get back to Paul on, but you said something about greenhouse gas emissions not being subject to the same exclusions as other information. Do you want to expand on that and perhaps that particular query, Preslava?
Yes, I would need to get back to Paul in more detail, and I'm happy to do so over email. But yes, information about emissions in general has special protection, as I mentioned, and the exemptions which cannot be relied on in terms of the EIRs are confidentiality of proceedings and confidentiality of commercial information, interest of the person who provides the information, and the protection of the environment. So in this case, the confidentiality of commercial information may not be applicable. But as I said, I think the full response would need to be reviewed in detail before I can make this assertion. Great.
What I'll do is I will pass that on to you, and we'll have a look into answering it. Is Valerie Dorant in the room? If Valerie's here, do you want to ask your question that you'd emailed around a Section 36 BECS being granted by ECU? Are you unmuted? I can't see if Valerie's there. I'm going to.
Oh, no, I'm sorry. I'm sorry. I'm not used to this one. Yes, and a Section 36 application has just been consented by the Energy Consents Unit on a greenfield site just on the periphery of South Inverness. And we're very interested because there are 42 conditions, some of which have to be complied with prior to construction starting. So we thought we would apply for under FOI, see when these conditions had been actually complied with, and then, follow it up if necessary with other things, just to keep pressure on, because it's actually in an area where there's a lot of, it's very near to a lot of housing, and in particular some tourist destinations.
Thank you, Valerie.
So, sorry. Can we use FOI to get this information of actually when the conditions have been complied with?
Preslava, do you want to answer that?
Yes. Hello. So in terms of Valerie's question, I believe why requests can be used for this, but this was discussed earlier when we met up that it might be more beneficial to initially start off by asking for the information directly to the planning department and find out when these reports are going to be uploaded. And I think this could be a more gentle approach to start with, unless anyone else from the speakers has anything else to add.
I think, Valerie, would you be able to mute again? I wonder whether their sound bouncing around a little bit. Thank you. Is there anything you'd like to say on that, Suzanne?
I'm so sorry, I missed a bit of the question.
Oh, it was about whether you thought it would be possible to use FOI to ensure that many of the 77 conditions that were put on a BESS construction in their neighbourhood were being carried out, because it's a lot to expect a community to kind of try and keep an eye on. And do you think it could be something useful to use an FOI for?
To make sure that you have information on all of the conditions?
Or to make sure they're being carried out before, some of them had to be carried out before the commencement of the development, and whether there might be an argument for trying to use FOI to check?
So that should be if I understand correctly, that should be in the final decision notice on the planning portal. It should list all of the conditions, and it should state which ones need to be completed pre-development.
Mm-hmm. Yeah, I think they know the conditions, what the conditions are. It's whether it's just all of the ones that have to be carried out and the difficulty. What we'll do, Valerie, is we'll send that question round and we'll write something to you around that. Perhaps gets that out to everybody, because some of these questions are really specific. So we will get back to you on that one.
I'll just say, Valerie, this is also worth. It depends on whether or not you are in conversation with your planners and how your relationship is with them. But you can always, request that they put the information up on the planning portal or send you the information first. But as Suzanne was saying, I think making sure that you do everything timely, because there is a bit of a time constraint for you there as well, isn't there? But that might be quicker, just if you've got a good relationship, just get them to put it up on the portal or send it to you.
Okay, thank you, Claire. So there's a question here from David Lynn about public consultation. And I think we all probably have seen this, that often consultation responses are quite generic and don't potentially get into some of the actual key issues, and they scoot over the top of a lot of them. So what he's asking is there a role for FOI in trying to find out perhaps a bit more about what is coming through about the analysis of the responses on for a consultation? Is that something you could answer, Preslava, do you think?
I haven't had experience specifically with requesting information related to consultations, but if my understanding of the system of freedom of information is correct, then information related to this should be available, and it should be possible to request it, and public authorities should be able to provide. I'm not sure exactly to what level of detail they should be able to provide information, but they should be able to provide a type of a mood surrounding the consultation. So specific themes can be reported on, and information such as age of participants, if it's recorded. Yes.
Thank you. Kirsty Towler has quite a specific question about something she's been seeking information on. Are you able to unmute and explain?
Yes, I've put down that I live in East Lothian. East Lothian is a particularly intransigent local authority, and doesn't like answering questions, doesn't like providing information, and they're completely obstructive. On a number of occasions, they've not provided information. I always have to appeal, and I've taken stuff to information commissioners, but sometimes it means that the information is of no use whatsoever by the time I get access to it. So I don't know what to do. Anybody got any suggestions?
Rafa, have you got something to suggest? And then I'll come to Suzanne, who's obviously had a lot of experience with local authority planning portals, planning authorities.
I would just like to ask Kirsty whether what is the purpose for searching for the information, and in what sense do you mean that it's no longer required? Could you elaborate?
Well, for instance, I'm a full transparency here. I'm a retired local authority planner, and on occasion I've asked for past files, and on one occasion it was to do with a community asset transfer. East Lothian Council told me they were going to charge me £150 to access the files. They didn't offer to copy them or whatever, but they were going to charge me £150 to look at some files. I asked them to review that, and they did, and they still didn't let me see it. I took it to the information commissioners, who told them that I couldn't be charged that amount of money. But it took a year. It took a year. By the time I was told, yes, you can see the files, the asset had been sold into the private sector. So it really is to thwart things. I have a recent FOI. I asked about a case to do with the imposition of a parking management scheme. Community objections. It's been done without any proper public recourse, improper public engagement. I asked about specific objections to one traffic regulation order, and I got back my own correspondence, duplicated, and evidence that there were 6 other objections, but none of that. So I know perfectly obviously that the information isn't being provided to me, so I've had to go back, and each time they will take the full number of working days to make it take as long as possible, and it goes on forever. It's demoralizing and shows a lack of willingness to engage with the public.
Thanks, Kirsty. Suzanne, I know that you've obviously had a lot of similar issues. Do you want to say anything about trying to get this information out of local authorities?
Yeah, I can really empathise, Kirsty. We faced a lot of the similar challenges. And I think in terms of, eventually we did get the information, albeit we've gone back. There's still the email. We still believe that there's emails missing, so we've gone back to the authority again and copied in the information commissioner. That I just actually did that today. But I think in terms of what you can do, I guess it depends on your situation. But for us, it is really frustrating when you get the information months after the fact and you can't use it in the way that you'd hope to use it. But for us, I think there's an opportunity again around press and to generate local support. I don't know if that's something that you can do to highlight these repeated ongoing failings. I think, again, potentially you're in a similar situation where even though you are putting in repeated requests and they're taking a long time to come back, that it's still that pressure that you're putting on the authority, and that they are aware that you are obviously on it and you're keeping a close eye on things. And Preslava, you might know better than I do, but I'm sure I read something the other day about the Scottish Information Commissioner. If they're getting repeated requests about the same authority and they're continually failing to respond to adequately to FOIs, I think it gets to the point that the Information Commissioner escalates it, and then it looks a bit more closely at the authority. Preslava, do you know anything more about that?
I think I have read something similar, but
Mhm.
I don't know any more details than you do.
I'll have a little look, Kirsty, and if we can,
Thank you.
yeah, and we can send something to you if that's okay.
Thank you.
Thank you. That's fantastic. Well, we've got a question from Kirsty Mingus. This one I'm going to read out here that they're currently chasing Renfrewshire Council on one of the conditions around compensatory planting. They approved the condition, the council approved the condition, but the compensatory planting is not sufficient. They've discussed this with the planners, but have got a very unsatisfactory response, and they'd like to go down the FOI route. She's not aware that any BNG, biodiversity net gain calculation, was done, and wonder if that is something they have to do. I think that biodiversity net gain is something that is just in planning law in England. We have something called biodiversity enhancement in Scotland, but it is still relevant to this case. So I wonder, this might be something to pass to Claire in the first instance, I'm wondering, or Nikki. Does anyone want to jump in? Or anybody?
I think up in the Highlands, they do have a biodiversity net gain kind of recommendation, don't they? But of 10%, but they don't have that in all local authorities. So yeah, it could be that. I'm not sure about Renfrewshire, to be honest, but so yes, it's an enhancement, and that's quite difficult to tie down. But this seems quite specific. I'm not quite sure what you'd be asking, Kirsty, in terms of what exactly, because you're seeing it on the ground. Are you wanting more detail on what has been discussed between the developer, or whether they've done any follow-up enforcement? I'm not quite sure exactly what it is you would be wanting information, or is it about the BNG calculation? Because that should be in the reports, the council reports, the officers' reports, and the decision notice, I would have thought. So,
Kirsty, do you want to unmute and perhaps just explain a tiny bit more about what exactly you're looking for?
Yeah, there was no mention of biodiversity net gain really, or no calculation carried out. So the compensatory planting that they've done off-site, they've planted 190 trees, 100 of which are on species-rich grassland, which is an inappropriate site for a woodland. And then the other area, so the Scottish Reporter said they had to plant a specific area of woodland mirroring the area that's been lost. So what they've done in the other site is they've spaced the trees really far apart. So they've filled in the area that was wanted, but it's not an area of woodland. It's an area with a few trees and lots of open grassland. So really what we want to find out is the conversations they've had with the developer and how they reached the agreement, because they also changed the location of where the compensatory planting would be. And also they said they had advisement from the council's tree officer, and a lot of the trees that have been planted are quite inappropriate for the site where they've planted them as well. And they have a sustainability officer, but they weren't involved in the conversation as far as I know. So I think it's really maybe just to find out. What I'm wondering is, you can follow a trail of emails, but what if they're having like Teams meetings and things like that? They're not minuted or recorded, so it's difficult to get evidence on those kind of discussions.
Okay, who's the best to answer this? I don't know if Preslava, you feel able to answer?
Yes, in terms of records of meetings and phone calls, normally there would be a policy for the relevant public authority whether these meetings are meant to be minuted and recorded in some way. If they are, then then members of the public can definitely request this information, and they should be able to have it. But that depends, of course, if they are not minuted, if they're not recorded in any shape or form, then the public authority can just rely on the exemption that they don't hold the information, unfortunately.
Thank you very much. We've actually got a message, a question that's for Suzanne from Anne Laird. I wonder if you can unmute there and ask your question.
Yes, thank you. Yes, Suzanne, speaking as a long-term planning application monitor person in Glasgow's West End for 25 years, I totally got your entire presentation, which was excellent. And also, clearly you've had to learn to be a lawyer. You know, that's what we all have to do. And on a subject which isn't obviously sometimes very intuitive, the way it works. So just to congratulate you. What I would have to say, the one thing you said at the end about shining a light on, or somebody said, shining a light on what the council is doing, that to me is the biggest gain at the end, whether or not you win a specific case. It's quite hard to win the first time you do anything, for goodness sake. And that's what the council relies on, of course, because everybody's doing it for the first time with any luck. They're all in different places and they're all doing it for the first time. And, you know, that does not help. We have been doing it across the West End with 300 applications a year for 25 years. Doing that is a big difference because they know what they're going to get from us and they know they have to deal with it. The question I'm asking you is whether, for the good of Highland, you or people connected in your organisation could start looking wider and at least make the council imagine, hopefully, and be able to do things and make them think you're watching them all along. Because that is, at the end of the day, it's unfortunately a big ask. But that's how you can really make a difference in the long term, is by preventing the council from thinking it's only ever playing a tennis match against novices, which in your case, you learn not to be very quickly. Thank you.
Oh, thank you very much for that, Anne. Do you want to respond to that, Suzanne?
Sure. Yeah. Thank you, Anne. And you're right. I'm sure we all feel like we become experts in things that we never imagined that we would become experts in. And it's a big, it's a lot to take on. But I really appreciated what you'd said, Anne, about shining a light and that being such an important part of that, whether we win or not. And that's really something, especially in the most recent FOI information that we've received, the 600-page document, with more recent emails, you really get that sense of the pressure that they're feeling from us, an internal correspondence saying, we need to get this right, because if not, they're going to pick up on it. There's a lot of that and a lot of concern about the judicial review. And I feel pretty confident that, sadly, if we'd gone about it a bit differently, or if things that, had gone a bit a different way, that we would have won, because there were so many issues with it, so many. And absolutely, that will not be unique to our site. So yes, about looking wider, I think that's really important, because we know what goes on all of the time. And it's just that people aren't watching and they're not putting the pressure on. So yes, I think in terms of so I don't actually live in the Highlands. It's my parents. I was brought up there, but my parents do. My dad actually became a councillor off the back of this. This is what, in part of the campaign, he was like, I need to do it from the inside. So, and he is really beating the drum for that site, but all for Invergordon and the area more generally, and really pushing the environmental and the well-being aspect of developments. So yes, I think that is a really important role. I'm not sure, it's something that we need to talk about within SOGS, about what we do next and what we can support with to keep pushing this message, even if it's not for that specific site. I mean, we still will for that site, but if it's if the development goes ahead, but there will be other developments that we can also support. And I think there's something important as well about all these little groups getting together, because that's something that we really valued to begin with, was learning from other groups and other local groups as well. So keeping in touch with them and, like you say, keeping that pressure on and hopefully making a bit of a difference.
Yes, very good. Thank you. What I would actually say, it's very good to have someone on the inside advocating for things. At the end of the day, the people you have to make a difference to are the actual planning officers, the ones who are sitting, actually dealing with the cases. And speaking as a retired teacher of many years in a secondary school, the one thing sometimes you have to do, which pays off, sometimes you actually have to do it for another local community at the beginning, get them started. With all your experience, you can kickstart them. Here's a couple of good emails to start with, and let the council think that this is spreading, if you like, because otherwise these things go to waste a bit. It's the actual planning officers and the actual FOIs and whatever you're doing, they need to know from the minute the first planning application comes out for consultation that there are people reading this who know what they're looking at. And I would say at this point, you do just have to get them the hint of that. You know, however much energy there's really there to do it, but they need to even get a hint that this could all be happening again for them to tidy up their act and build on what you're saying. They're looking scared. Oh my God, there is someone out there. They've gone on for years and nobody's blooming watching them. Of course they do this. So I think you need to keep up the fear now, in a good way, but you need to do it on the next few applications that maybe, I think Highland does its decisions in certain sub-areas, doesn't it? Because it's such a wide area. So you've got sub-planning committees. So I would maybe restrict your activities to one of those, and anything reasonably big happening that could go wrong, I think you could achieve that with not too much effort. And I might even offer to help, but you never know. But
I might hold you to that, Anne. Thank you. That's brilliant advice. Thank you.
Just a thought.
It's really good to have this kind of long experience and the wisdom from someone who's been doing this over such a long period. And I think, you know, something that I've gathered from this meeting is that, you know, if perhaps we're all working alone, it feels lonely. But if we all get together and learn from each other, it's really, really good. I'm going to draw it to a close now. I'm going to say thank you so much to our two speakers, to Claire. I'd also like to reiterate Suzanne's appeal. So we haven't asked for any donations to APRS or Planning Democracy for this, but so that we can kind of frontline Suzanne's appeal. And I am really grateful for everything I've learned and for hearing from all of the people on the ground who are experiencing this. So I'd like to highlight, we've got another webinar, which is going to be about accessing environmental justice. It's really focused to the next election. So the May elections, obviously a big one for Scotland. Both ERCS, Environmental Rights Centre Scotland, ourselves, APRS, and Planning Democracy have manifestos that we're trying to get into the discussions around the election, and this will be really specifically around things that are in the manifestos of those three organisations. And so we really encourage you to come along to learn how to perhaps change things and how we can put pressure on to change the systems to make them better for people, for communities, for nature. So we will see you then. Now, I haven't got anything open telling me the date. I think it's the 24th of March, but
10th of March.
10th of March. It's on the 10th of March. It's on our email, on our website, and I will also send an email out to everybody with a link to the video from this, and we'll put a reminder on for it. So hopefully see you then. And goodbye, everyone, and perhaps the speakers just stay on for a wee bit and we can have a little wrap up. But thank you, everyone, for joining us.